Hi, everybody. I'm Bob Marone for Westchester Talk Radio, and once again, we are with our friends from Hightower Westchester. We're here today with Peter Lang, Managing Director and Partner at Hightower Westchester, and David Work, Managing Director, Estate and Financial Planning at Hightower. And today, we are talking about estate planning. Peter, good morning.
Good morning, Bob. Great to see you again, and pleasure to welcome my colleague David Work with us as well today. So it's always great to spend some time, and the topic of estate planning is always a pretty interesting one, and certainly something we talk with clients about on a regular basis. And it's really just as important as the financial planning that we do for client. Each part is related to the other and kind of needs to be looked at in its entirety. And people think estate planning is really only for the wealthy. Oh, I don't need to bother estate planning. I don't have enough money. But that's not true. Everybody needs to do it. You need to have, the basic documents available for your family, because you're not doing it for yourself. You're doing it for your family. And it's just as important for someone in their 40s as it is for someone in their 80s. The documents might need to be changed and addressed for someone who's 40 years old versus someone who's 80, but everybody needs to have it.
Thank you for that overview, Peter. Can you tell me how you work with clients and what role David plays?
Sure. As part of our planning process, we go through an in-depth financial planning and estate planning process with clients. And over the last few years, as Hightower has grown, we were fortunate to be able to bring on someone like David, who heads our estate and financial planning group. And we can bring David in to meet with our clients on an as-needed basis. David has over 20 years of experience. He's an attorney, and I'm going to let David, go over some of his background at this point, because he can do a better intro than I can for him.
And David, before you answer Peter, I want to thank you to Westchester Talk Radio and to our broadcast telecasts here. Welcome aboard, sir.
Bob, thank you for that welcome aboard, and I'd like to thank both you and Peter for having me on today. So just a quick bit about my background. I've been with Hightower for almost 2 years. Before joining Hightower, I was a wealth strategist with Merrill Lynch's Private Wealth Management Division for almost 23 years. And then before that, I was an attorney in private practice. So I actually was an estate planning attorney, focusing not only on estate planning, but also on tax-exempt compliance and creation. So done a lot of work in the charitable space. And then I'll just fast forward back to today. A part of my passion is helping to educate the future. It's a way I can give back. So I'm actually an adjunct faculty member at a local university here, teaching financial literacy to graduating seniors.
Can you give us an example of the types of cases that you may be called upon to advise?
Yeah, we work on a whole range of cases. So if you think in your minds, families that have done absolutely no planning, all the way to the other end of the spectrum, those families that have done very complex planning, and maybe they're considering other options that may exist. So whether the family has a taxable estate, which, as we know right now, the estate exemption is about $13 million per spouse, so $26 million and above. So we work certainly on those types of families, but for the non-taxable estates as well. So families that have a few million, $5-10 million, we work on those types of families as well. And then in terms of types, I would say if you're a business owner, we've worked with you. If you're a professional like an attorney or a doctor or an accountant, we've worked with you. Or look, maybe you've just inherited a lot of wealth and you're looking to see what options you have and what kind of planning you can do. We've worked with that. So we've really run the gamut, Bob.
Wow, you sure do. Peter, let's shift gears a bit. Let's talk about some common estate planning mistakes that you've seen people make during your career.
Sure. So Bob, I've been doing this for a little over 30 years at this point, so probably a couple more than David, or pretty close anyway. And the one that I still see, and I'm dealing with a case right now where a husband died without a will, simply had done nothing, and it was a fairly substantial, a few $1 million. So it's not about he didn't do things to help structure it from a tax standpoint because it's below, as David said, the $13 million threshold. But he left his wife, and he was an older gentleman, so he wasn't like young, so he was an older gentleman, but he left his wife without a good handle on things. And she's been, playing catch up, trying to figure all of this stuff out. He was running a business, there's pension, it's a whole lot of stuff, and it's going to take us a good amount of time to untangle it and to deal with it. Her kids have been very attentive to her adult children, and they've been very helpful, but it's a process, and a lot of it could have been avoided, even with a simple, I love you, Will, I love you, dear, you get everything, but he had nothing in place. And then the other common mistake that I see, which happens, is people leaving like a very specific asset to a child or a grandchild. I'm not talking about the family heirloom, the silver cup, the special plate for the holidays kind of thing. I'm talking about, I've actually seen in documents I've read, I'm sure David will nod his head, is that I've seen clients leave a specific stock to somebody. Like, I'm going to leave shares of XYZ company to, my child. The issue with that is, well, what happens if XYZ gets sold? Then what does the child get if that's all they were left? So, we highly recommend, leave a dollar amount, leave a percentage. Don't leave a named security to somebody, because it could disappear by the time it's ready to be inherited. And I'm sure David's got a whole bunch more to share, since he's even deeper involved in this process.
David, please.
Yeah, I've got a couple to share with the audience today. So the first one relates to beneficiary designations. So one of the things that I see is that the designations made on the IRA or other type of account like that don't line up with the actual will or living trust structure. And I'll just give a quick example. So let's say in the will, it says, when I die, there are trusts created for my beneficiaries, as my heirs, as one example. Well, the retirement account says, when I die, it goes to my spouse and then equally among my remaining children. That is an outright distribution versus a distribution that would be protected and under the provisions of a trust. So that is one example where I see a lack of coordination between retirement accounts and the actual wills. So that's one example. Oh, and while we're talking about titling, I'm going to throw in a bonus one here. Join with right of survivorship. That's an account type that if you have your brokerage accounts titled that way, you can have all of the best tax planning and trust planning inside your wills, but it's going to get bypassed at the death of the first spouse, because all of the assets pass immediately to the joint with right of survivorship owner. So that's the first one with a bonus. The second one relates to lining up goals and objectives with the actual legal documents. And I'll give an example there. We talk with many families, and they express concern about their adult children over issues like divorce, or maybe their son or daughter is in a profession that attracts liability, like they're a doctor, so they're concerned about asset protection. And quite honestly, maybe sometimes they're just concerned about their adult child's responsibility level when it comes to spending or using money or investing money. So we have this conversation, we hear them express those concerns, and then when we review the estate documents, it essentially says something like this. When mom and dad have passed away, the assets, even if it passed into trust, there are age attainment clauses that say when they turn 30 years old, they get a third. At 35, they get another third. And then by age 40, they get the rest of it. So then in my mind, I'm thinking, well, great. You have these concerns. You actually made some steps to protect it, right? There is a trust. But by the time your adult child is age 40, now it's all outright in their own name. So what does that mean? The assets are now exposed to creditors, potentially subject to divorce. And hey, if they've got that spending issue, the protected provisions of the trust are no longer applicable, and they can just do whatever they want with the money. So I see sometimes, Bob, a lack of alignment of what are my concerns and goals with what does my document actually do when I'm not here.
It's certainly valuable that you're a lawyer. Wow. You guys have seen a lot. Now let's shift gears and talk about trends or new ideas you're seeing today. David, let's go back to you.
Yeah, so I mentioned earlier that, I have a background and focus on the charitable side of things, whether it's and ongoing compliance. So one of the things that we talk about a lot in our consulting and planning are structures like private family foundations or donor advised funds. And those certainly have great application and are very meaningful. But one of the things that we're starting to see families also think about is this structure called a charitable LLC. So in other words, it's just your standard state created limited liability company, but the family has a charitable focus. So in other words, they want to still ultimately give to charity, but they don't want the restrictions of, say, a private foundation, which has self-dealing rules. You're limited on the types of investments that you can do, and you also have a 5% distribution requirement. There's a lot of compliance that goes with that. So what this charitable LLC does is it allows a family that has charitable intent to invest with full freedom. They don't have that required annual distribution, that 5% that, say, a private foundation has. But guess what, Bob? They can continue to make charitable gifts when they want to, and the deduction will flow back through to the owners of the LLC because it's a pass-through entity. So we're seeing families that want to have flexibility, that don't want to come under the IRS's strict compliance of things like for private foundations, but they still want to maintain that charitable focus and charitable legacy, pass that on to that next generation. And so I'm starting to see families create more of this type of structure.
Wow. Peter, what have you to say about this?
That's a really interesting idea, and appreciate that idea, David. I think one of the things that we're seeing right now is a lot of changes in IRA accounts when it comes to estate planning. And there are a couple of different ways, right? When Congress passed the Secure Act 1.0, they did away with what was known as the stretch IRA, where you could theoretically pass an IRA down for generations to come after, let's say, the large earner of the family, husband or wife, whichever one, had this large IRA. Spouse one passes away with a large IRA, leaves it to spouse two. And he or she can continue to collect that benefit and keep it as their own kind of forever, as long as they live. It used to be you could then, if you passed it down to the next generation, to the children, they could continue it on. So you could have, these IRAs that would be called stretched out and could go for decades in some cases. They stopped that. And so now those IRAs have to be spent within 10 years. When it goes down, not to the spouse, but to that next generation, to the child or to the grandchild. So now there's, we got to think about that a little bit. One of the ways you do it is potentially you accelerate the distributions for mom or for dad to take out maybe a little bit more money to shrink the IRA, because that IRA, while it will pass estate tax free, presumably if it's under 13 million to the children, when the kids start pulling that money out, that's going to be completely taxable income to them. And sometimes mom and dad don't really care, and they'll say, hey, it's their problem, let them pay the income tax. And that's okay. But other times, if they don't want to do that, they can either accelerate their own distributions from it, or what we've done for some clients is we start doing conversions into Roth IRA accounts. So that means mom and dad are paying the income tax now. The kid gets the Roth IRA upon mom or dad passing away, and the Roth distributions that come out, even though they have to come out within 10 years as well, come out tax-free. So that just requires some planning and, some coordination with the attorneys and the accountants to make sure, because Roth, the Roth IRA feature is really powerful tool for, passing down larger sums of wealth.
David, any ideas you can share on this topic?
Yeah, so Peter mentioned Secure 2.0. There are a couple of other things relating to IRAs that came out of that. One of them relates to families that have children with special needs, and they want to name a supplemental or special needs trust as the beneficiary. The IRS has provided some under Secure 2.0, some clarifications around actually doing that. And they've also changed the rules that allow for the naming of a charity as the beneficiary of the special needs trust as a remainder interest. So I know when I've been talking with attorneys that are advising families with those situations, sometimes, when they get to the end, they want to leave the money to a charity, and there have been some problems in the past. So that issue has been solved. One of the other things that Secure 2.0 has done, it's expanded the qualified charitable distribution rules, or the QCD. Mm-hmm. And so one change is, and our listeners may remember, you can satisfy your RMD up to $100,000 in a year. Well, that was a flat number. Under Secure 2.0, they've actually indexed that for inflation. So just know that number will tick up over time. And then they've also added a couple of other options. One is for those individuals 70 and a half or older, they can make a one-time $50,000 distribution to a charity through what's called a charitable gift annuity, or a CGA, or they can actually make that same amount and contribute it to a CRT. So the IRS has created some expanded options with respect to the qualified charitable distribution.
Wow, that's a lot of great information, gentlemen. Any closing thoughts?
I would say the closing thought here is, the rules, the laws, they're always changing. And so people, I think the most important thing is people need to make sure that they have documents, and they need to make sure that their documents are, up to date. I just met with a client earlier today to start doing financial planning, and they filled out our questionnaire, and they wrote in there, their will was last updated in 1992. And so I looked at them and I said, I think it's time to get updated. And they were like, yeah, after we finish this, that's our next stop. So, you need to have documents, and you also need to make sure that they're updated and reviewed probably on a 3, 5, 7-year basis, because laws and rules change, and you want to make sure that your documents are up to date and taking the best advantage of whatever the newest rules and regulations are in this particular area.
And what about you, Dave? Anything you'd like to conclude on?
Yeah, I'll just continue the theme of what Peter just mentioned, which is the laws are always changing and things are evolving. So we talked earlier about the federal estate tax exemption being close to 13 million. Mm-hmm. And many of our listeners may know that exemption is currently set to sunset in 2026 and decrease by almost half. So again, continuing this theme of the laws are changing, we have a couple of years where clients can take advantage of the exemption levels being so high, the highest they've ever been, because what happens when the clock ticks over to January the 1st of 2026, any individual person will lose approximately $6 or more million of estate tax exemption. Let me translate that into real dollars, Bob. That's almost almost $2.5 million of estate tax liability. So we have a window to think about this. We don't have to rush into it tomorrow, but let's be mindful and let's be thinking about what are some things. Is it appropriate to do a spousal lifetime access trust or a grantor trust and start to transfer assets out of the estate? So let's have that conversation.
Well, conversations and analysis and reviews are an important part of all of this, aren't they? First of all, Dave, I want to thank you for joining our little crew here, and continued success. And I want to remind people, David is the Managing Director of Estate and Financial Planning at Hightower. And of course, always with us, Peter Lang, Managing Director and Partner at Hightower Westchester. I want to thank both of you. This was very, very informative. Thanks again.
Thanks,
Have
Bob.
a great day.
Thanks, Bob.
Hightower Westchester is a group of investment professionals registered with HighTower Securities, LLC, member FINRA and SIPC, and with Hightower Advisors, LLC, a registered investment advisor with the SEC. Securities are offered through Hightower Securities, LLC. Advisory services are offered through Hightower Advisors, LLC. This is not an offer to buy or sell securities. No investment process is free of risk, and there is no guarantee that the investment process or the investment opportunities referenced herein will be profitable. Past performance is not indicative of current or future performance and is not a guarantee. The investment opportunities referenced herein may not be suitable for all investors. All data and information referenced herein herein are from sources believed to be reliable. Any opinions, news, research, analyses, prices, or other information contained in this research is provided as a general market commentary. It does not constitute investment advice. Hightower Westchester and Hightower shall not in any way be liable for claims and make no expressed or implied representations or warranties as to the accuracy or completeness of the data and other information, or for statements or errors contained in or omissions from the obtained data and information referenced herein. The data and information are provided as of the date referenced. Such data and information are subject to change without notice. This podcast was created for informational purposes only. The opinions expressed are solely those of Hightower Westchester and do not represent those of Hightower Advisors LLC or any of its affiliates. Hightower Advisors do not provide tax or legal advice. This material was not intended or written to be used or presented to any entity as tax advice or tax information. Tax laws vary based on the client's individual circumstances and can change at any time without notice. Clients are urged to consult their tax or legal advisor before establishing a retirement plan.